House Bill 815, an act to amend and reenact a section of the Code of Virginia relating to the method of execution. The governor's recommendation is printed in the calendar. It's available online and before the body.
Speaker.
The gentleman from Fairfax, Mr. Simon.
Point of order.
Gentleman has the floor.
Mr. Speaker, it appears that the substitute before us talks a lot about making and entering into contracts and rules for what those contracts should say, and there's a bit of a procurement bureau bill for the Bureau of Prisons, or the Department of Corrections, I should say. And the bill that it amends was just a little 3-line bill about what happens in the event that someone doesn't choose the method of execution, what the final method should be. So I would ask the chair if the amendment is properly before us, is it germane to the bill that it attempts to amend?
Let's take a look at it. You might want to come up here. House will come to order. House will come to order. The purpose of the original bill relates to the method of execution. I believe that's what the governor's substitute deals with as well. So I'm going to say it's properly before us. The gentleman from Prince William, Mr. Miller.
Thank you, Mr. Speaker. Mr. Speaker, the governor's amendments to House Bill 815 aren't exactly what I wanted in my original bill. And I did have my own questions about this bill, and that's why I asked for the governor's office to re-examine it. And I also asked for an opinion from the Attorney General's office, as did Senator Survell and Delegates Marcus on this legislation. Mr. Speaker, the governor's amendments are constitutional. They are legal. They also showed how there's 3 other states that also have the death penalty, have very similar, if almost not identical, type of legislation, and this has passed the muster in those states as well. Mr. Speaker, with that being said, I believe everyone here has seen, heard, or read about this bill. Earlier this morning, I sent out the 13-page opinion from the Attorney General's office, which was very definitive and very strong in his wording that this is constitutional and is legal, and therefore I would ask that the body accept the governor's amendments.
John Fairfax, Mr. Lemonian.
Thank you, Mr. Speaker. Speaking to the governor's recommendation.
Gentleman has the floor.
Thank you, sir. Mr. Speaker, ladies and gentlemen of the House, I hope we would defeat or reject this recommendation. For the benefit of the first-term members, we defeated on the House floor a year ago Senate Bill 1393, a very similar bill related to surrounding the production of lethal injection drugs in secrecy, taking them out of the domain of the Freedom of Information Act. As problematic as that bill was, it actually included a provision that made sense. That's not included in this recommendation. I'll read it to you. Nothing in this section shall prohibit the Board of Pharmacy from inspecting or investigating a pharmacy or outsourcing facility compounding drugs pursuant to this section or investigating a person authorized to compound drugs pursuant to this section. Now, that's taken out of the recommendation that we have before us. I don't recall there being an explanation from the governor on this particular measure, but I'm going to guess that someone determined that the Board of Pharmacy wasn't the appropriate entity to be involved in evaluating lethal injection drugs or their production. The problem is the governor didn't replace the Board of Pharmacy with anything else. And so we won't know who the producer is. We won't know where they're located, whether they are in the United States or outside the United States. We do know that other states have gone internationally for these drugs. We will have to trust that the drugs that they deliver are what we expect, are what the producer says they are, and are in accordance with whatever local, international, national regulations or laws apply. In other words, trust, but don't verify. And when you put this in context, I would just point out that if this becomes law, the Commonwealth of Virginia, we the people, the legislature, our citizens, would be more certain about the chemical composition of the asphalt that VDOT buys to put on our roads than we would about the drugs that we put in the veins of someone we want to execute. I don't think this is about for or against the death penalty. I think it's about getting this right. I think we ought to defeat this measure, and maybe next time the governor can come back with a bill in January, not April, and we'll get it right. Thank you.
The gentleman from Fairfax, Mr. Simon.
Mr. Speaker, speaking to the bill, or speaking to the governor's amendment.
Gentleman has floor.
Mr. Speaker, I don't often agree with Delegate Lemunyan, the gentleman from Fairfax. We had a lot of talk today about flipping of votes, about making some of these very, very serious issues too political. And I think that this is an example of an issue where I think we can put the politics aside. I mean, if somebody like me gets up, I know it probably flipped a couple of you that were thinking you were going to go one way, maybe the other way, because, hey, look, if Simon's for it, I got to be against it, or the other way around. But I hope that that's not what you're thinking. I hope you're thinking about this on the merits and about what it does and about what the policy of the Commonwealth of Virginia ought to be when it comes to how we make the decision to execute the condemned that are on death row. 22 of you all, they're still here, I counted up from last year, voted against Senate Bill 1393, when a very similar bill was on the floor in this body with Senator Saslaw as the patron. I would hope that those of you that didn't like that bill last year because of the secrecy, because of the problems that bill had last year when it had a Democratic sponsor, would still have those same concerns about this bill, even though this bill's got this delegate from Prince William's name on it. There are three ways, actually, that this bill is even worse than the bill that we killed in this body last year. One is the issue that the gentleman from Fairfax, Mr. Lemunyan, raised. Who's monitoring the facilities that produce these drugs? Right? We've specifically, in this version, exempted these pharmacies from oversight by the Board of Pharmacy, the Board of Health, anybody, any board that supervises the healing arts, the caring arts. We said, we let you guys off the hook. You don't have to be part of this process. We'll take you completely out of this process. Now, I've heard, the definition of a pharmacy is still controlled by that section. We still talk about what the definition of a pharmacy is, so it's still got to be, it can't be just Joe compounding drugs in his basement. But actually, the definition of pharmacy that we adopt in this bill means every establishment or institution in which drugs, medicines, or medicinal chemicals are dispensed or offered for sale, or a sign is displayed bearing the word or words pharmacist, pharmacy, apothecary, drugstore, druggist, drugs, medicine store, drug sundries, prescriptions filled, or any similar words intended to indicate the practice of pharmacy is being conducted. All right? So that's the list of facilities that are authorized under this statute to create the compounds that we're going to use to experiment on these condemned to find out if this is going to do the job well enough to kill them. So, again, do we want to have that level of secrecy? Do we want to have some oversight? The labeling of the drugs has changed significantly. Last year, this bill went through the process. It went to the House Courts of Justice Committee. The folks on the House Courts of Justice put some specific requirements in there. They said that you got to have a label that talks about the active ingredients, the strengths, the facility control number, the appropriate date beyond which it's no longer good, but based on regular pharmacy standards. The new bill just says it's got to have a label that says what it is, how much there is, and give some sort of expiration date. So we don't know what's in that. We don't know, and we can't find out because we've also said that the identity of anybody involved in this process is to be kept a secret. And it can't be discovered except for good cause shown, but we don't know what that is, right? Last year, when courts got a hold of this bill, you guys amended it. You did your jobs. Now, some of us didn't go far enough, but you did your jobs. You set up a process by which there was some guidance for getting this thing done. This is just going to leave it up to some court to decide in a civil matter, is good cause shown or not. Sometimes they'll say yes, sometimes they'll say no. When they say no, that's one more thing to appeal. When they say yes, the next question is it going to go under seal or not? What's going to be sealed? How much of it's going to be sealed? Mr. Speaker, members of the House, if you didn't like this bill last year when it was Senator Saslaw's Senate bill, you really, really shouldn't like these amendments. This bill is worse than what we saw before. If you want more time to work on it, we could do that again as a new bill in January. I thought about maybe making a motion that this isn't specific and severable because I don't think it's not. Get it back before us in its original form, but I don't think that really gets to the point. I think the point is this bill is not ready for prime time. It's not something that we ought to be doing, and I would hope that it would be the pleasure of the body to vote no and reject the governor's amendments to this bill. Let him take it back in its original form. If he wants to veto it, so be it. Thank you, Mr. Speaker.
The gentleman from Fairfax, Mr. Albo.
Speaker, speaking the amendment.
Gentleman has the floor.
Speaker, members of the House, the gentleman from Prince William wanted me to share you some information that I received in the Attorney General's opinion. So what's my concern last year and my continued concern this year was that would a defendant or the defendant's attorney ever be able to find out whether the medication they're putting in his arm is in fact the appropriate medication. So in other words, are they putting are they putting cyanide in there? Are they putting borax in there? You have no idea. And so it was very important to me that the defendant and his attorney would know that a certified compounding pharmacy was used and that the medication was correct. So that was included in this memo. And what the Attorney General's memo says is that while the information would not be discoverable in the case in chief on a habeas corpus petition, you could find out if you filed a civil rights claim. So the Attorney General's memo says is that finding out, so the person has already been convicted, okay? So you would not file a motion to attack the conviction because it's already been convicted. What the motion would say is, I think my civil rights are being violated because I don't know whether the substance being used is proper. And that would be under 42 U.S.C. 1983, a violation of civil rights. And then the Attorney General's memo says that the court would be able to provide that information to the defendant and his attorney. Now, I don't practice in the area of law, so I would have to rely on the experts at the Attorney General's office who have been doing this for years, and they have assured me that in the end, the defendant and the defense attorney would know. Thank you.
Shall the House agree to the governor's recommendations? Clerk will close the roll.
Ayes 47, noes 51.
Ayes 47, noes 51. The governor's recommendations are not agreed to.